Coming up, another episode of The Deep Dive, exploring radical ideas. A podcast produced by Bob Rash.
That delivers a logical analysis of objective reality, grounded in rational principles. We will explore relevant facts and radical ideas based on the axiomatic principles of identity, causality, and consciousness, on reason as an absolute, on rational self-interest as a moral guide, and on the ideals of privacy, freedom, and justice.
Okay, I want you to start by visualizing two very specific, very real scenarios. And, close your eyes if you have to.
All right, I'm with you.
So, scenario one, you're sitting at your kitchen table, it's late at night, maybe you've got a cup of cold coffee next to you, and you are filling out some kind of government form.
Oh, the worst.
The absolute worst. Maybe it's a permit renewal or a tax return, or maybe a registration update. You're tired, you miss a box, or, you misread a deadline and you sent it in 5 days late. That's the act. A clerical error, a simple lapse in attention.
Okay, I'm there. It's mundane, it's frustrating, it's completely administrative, there's no malice.
Right, no malice. Now hold that feeling. Scenario two. A man walks into a crowded bank downtown. He's carrying a shotgun.
Okay.
He fires around in the ceiling, shattering the lights. He pistol whips a security guard, terrorizes the staff, screams at the customers to get on the ground, and then walks out with a bag of stolen cash.
Wow. Yeah, the energy there is, it's viscerally different. One is a mistake, paperwork. The other is a violent, deliberate trauma inflicted on real human beings.
Exactly. And here's the fundamental question we are asking today in this deep dive. Should the government's reaction to those two events look the same?
Right.
Should the tools they use, the surveillance, the SWAT teams, the detention cells, the handcuffs, should they be identical for the person at the kitchen table and the person with the shotgun?
Well, instinctively, every single person listening right now is just screaming, no, of course not.
It seems obvious.
To treat them the same would be insane. It would be a complete violation of common sense, of fairness, of everything we think of as justice.
And yet the document we are analyzing today argues that our legal system is drifting dangerously close to that exact insanity. We're seeing a legal landscape where the distinction between a, quote, bureaucratic foul and a violent felony is being actively erased. We're witnessing what the author calls a collapse of proportion.
And that phrase is so powerful, a collapse of proportion. Because when you lose proportion, you don't just get strict law enforcement, you get tyranny. You get a system that can no longer distinguish between a citizen who made a mistake and a criminal who wants to destroy society.
So today, we're doing a deep dive into a really fascinating and I think incredibly timely piece of writing. It's an article titled Severity, Law, and the Collapse of Proportion by Roberto Rachewsky. It was published just recently on February 4th, 2026.
And what makes Rachewsky's work so compelling, I think, is that he hasn't just written an opinion piece complaining about the government. That's easy to do.
Right. Anyone can do that.
He's actually built a framework. He calls it the Composite Severity Index. It's basically a scale from 1 to 10 that categorizes wrongdoing based on actual harm, not political outrage or, media hype.
I love a good framework. It really does help organize the chaos of the world. But before we get into the levels, and we are going to walk through this entire scale, from the absolute nightmares at level 10 down to the minor annoyances at level 1, we need to talk about the philosophy behind it. Rachewsky uses this phrase that really stuck with me. He calls proportionality the spine of justice.
It's a perfect metaphor, isn't it? I mean, think about what a spine actually does in a body. It holds the head and the body in alignment. It allows for movement, for flexibility, but most importantly, it carries the nervous system.
It communicates reality to the brain.
Exactly. It tells the brain the difference between a gentle touch and a serious injury. If you sever the spine, the body collapses. It becomes paralyzed. Rachewsky is arguing that our legal system is an organism just like that. It relies on its nervous system knowing the difference between a tickle and a stab wound.
That's a great image.
Yeah.
If your body reacted to a tickle the same way it reacted to a stab wound,
Yeah.
Massive adrenaline dump, shutting down non-essential organs, going into shock, you wouldn't survive for very long.
You'd brain yourself out. The system would destroy itself. And Rachewsky argues that a justice system without proportionality is exactly that. A body in a constant state of shock. It has to differentiate. It must distinguish between, say, civil transgressions and actual crimes.
Or between negligence, oops, I didn't mean to do that, and intent, I planned this for weeks.
Yes. Or between a technical violation, like your paperwork error, and the intentional destruction of human life. Without those distinctions, the word justice loses all meaning.
But isn't harm a little subjective? I mean, if someone scratches my brand new car, I might feel like it's a level 10 catastrophe because I love that car.
Yeah.
The law can't operate on my mood right.
Precisely. And that's why he's so careful about this. That's why Rachewsky builds his scale on two very objective pillars. He asks two hard questions to determine where an act falls on the scale.
So what are they?
First, how much real damage is done to third parties? And he's clear about this. Not theoretical damage, not you offended the dignity of the state. Did you actually hurt a person? Did you destroy their property? Did you take their life?
So tangible, measurable harm.
Yes. And second, what is the severity of the penalty the law assigns? He's connecting the act to the consequence that our own legal tradition has established over centuries.
It's a reality check.
Exactly. And here is why this matters so much right now. The text warns about a slippery slope, but it's more specific than the usual cliche. Rachewsky argues that when these minor civil violations are rhetorically inflated into grave crimes, the state begins to operate without brakes.
Without brakes.
Yes.
That's a terrifying phrase. It implies that once you justify using maximum force for something like a paperwork error, you've essentially removed the governor on the engine of state power.
That is exactly the point. The text asserts, and this is a direct quote, that enforcement without hierarchy ceases to be justice and becomes raw power.
Raw power.
If a government agent can kick down your door for a zoning violation with the same justification that they used to kick down the door of a terrorist cell, they are no longer serving justice. They are just exercising dominance.
And the scale we're about to go through, it's not about excusing wrongdoing, is it? He's not saying a level 2 violation is okay.
Not at all. Rachewsky is very clear on that. It's about ordering it correctly. It's about ensuring the response is sane, rational, and proportionate to the actual harm caused.
All right, let's get into the scale itself. We're going to start at the top with the absolute worst of the worst and work our way down. This is section 2 of the text, the top tier. We're talking levels 10, 9, and 8.
Yeah, brace yourself. This is the dark stuff.
Level 10. The definition here is existential or irreversible harm.
This is the absolute peak, the summit of wrongdoing. We are talking about acts where there is no undo button. The harm is permanent, and it's often on a massive scale, or it's something that threatens the very existence of the nation.
The examples he gives are stark. Genocide, terrorism causing death, aggravated first-degree murder.
And treason in wartime. He also lists things like aircraft piracy with fatalities. These aren't just crimes against a single person. In many ways, they're crimes against humanity itself. They strike at the very structure of civilization.
Talk about that a little more. What makes treason in wartime, for example, a level 10?
Well, think about what it is. It's an attack on the collective. It's an attempt to destroy the very entity, the state, that is supposed to protect everyone from harm. Like genocide, it's an act that threatens the existence of the protector itself. The harm is existential.
And so the penalty has to reflect that. Life imprisonment or the death penalty.
There's a moral clarity here that's, it's almost comforting in a way. I don't think anyone listening, regardless of their politics, thinks genocide should be a ticketable offense. We all agree the state should come down with the absolute hammer of justice here.
Right. It's the worst of the worst, and there's no debate.
Okay.
Then we move down just one notch to level 9. Mass or systemic lethal harm.
So still incredibly severe. We're talking about extreme bodily harm and deep, lasting societal damage. The examples he gives here are things like felony murder, serial rape, child rape, and torture.
He also includes large-scale drug trafficking that results in death.
Yes, because in that case, you have a systemic enterprise that is causing lethal harm on a massive scale, even if the kingpin never personally pulls a trigger.
These are things that just shatter lives completely. Now, torture is an interesting inclusion. It might not always result in death, but he puts it right there at level 9. Why?
Because it destroys the integrity of the person. It's a deliberate, methodical dismantling of a human being's psychology and physiology. Rachewsky argues that the state responds with such massive force here because the violation of the individual is absolute. It's a crime against their very humanity.
It's an attempt to unmake a person.
That's a great way to put it, yes.
Okay, and then the last of the top tier, level 8. Severe, violent, or societal harm.
So here, the act creates a high risk to life, or it causes mass trauma, or it threatens to destabilize civil order itself.
The examples here are things like armed robbery with injury, manslaughter, violent racketeering. So think of RICO cases against the mob and insurrection.
Large-scale arson is in there, too.
Right. Insurrection is an interesting one to see there. It's a direct threat to the structure of governance.
It is. It's a direct attempt to replace the rule of law with mob force. But notice Rachewsky's precision here. He places it at level 8, not level 10.
Why the distinction?
Because unless the insurrection results in mass death or a complete existential overthrow of the government, it sits just below something like genocide or treason. It's a scorched earth crime against the system for sure, but the scale demands we be precise. The harm, while massive, is not necessarily the same as the systematic extermination of a people.
So if we look at this whole top tier levels 10 through 8, we're seeing a very clear pattern. These are direct, violent, and often lethal threats to individual lives and the fabric of society.
Exactly. And because the harm is so catastrophic, the state's heavy hand is justified. This is the social contract in action. We, the people, give the government the monopoly on force. We give them the SWAT teams, the prisons, the weapons, specifically so they can deal with this tier of crime.
I give up my right to vigilante justice because I trust the state to handle the serial killers and the terrorists.
Yes, we tolerate a powerful state because we need something strong enough to stop a level 9 threat. But as you said earlier, if the state starts using that power elsewhere, well, that's where all the trouble begins.
That is the crux of the entire argument.
Mm.
Okay, let's move into the middle tier. This is section 3 in the text, and it covers levels 7, 6, and 5. And this is where it gets, I think, a lot more nuanced and frankly where the legal theory gets really interesting. This is where we start to see how context can change everything.
This is the transition zone. We're moving from what you might call pure violence down to high harm. And it's where the intent and, crucially, the history of the individual really start to matter in the analysis.
Level 7 is defined as serious felonies, high harm, non-lethal.
So the definition is severe harm to persons or institutions. The examples he provides include sexual assault that is non-fatal, armed burglary, major fraud, we're talking bank fraud, wire fraud, things that can wipe out a company or a family's life savings, and money laundering.
Okay, so in all these cases, nobody died, but serious, life-altering damage was done. You've traumatized someone for life, or you've stolen millions of dollars.
Precisely. But there's a crucial detail on the level 7 list that I really want to flag because it sets up the rest of our discussion on immigration and individual rights.
What is it?
Rachewsky lists illegal reentry after removal with prior violent felony.
Okay, let's pause right there and unpack that. With prior violent felony.
That is the operative phrase. The physical act of reentering the country after being deported is the same physical act no matter who does it. But the context, this person's documented history of violence, elevates the severity of the new offense to a level 7.
So the state is viewing this person not just as an administrative violator, but as a recurring, tangible danger.
Exactly. They have already proven they are willing to hurt people based on that prior violent felony conviction. So the law says your act of defying a removal order is now a much more serious threat because of who you are and what you've done.
So it's not just you crossed a line, it's who are you, what have you done before, and what risk do you pose to the community now?
Precisely. It's looking at the whole picture. The legal system is assessing the risk profile, not just the technical violation in a vacuum. Context is everything.
That makes a lot of sense. Okay, let's move down to level 6. Felonies with moderate but real harm.
Here the text says that rights, economic security, or institutional integrity are harmed. The examples are things like grand theft, identity theft, perjury, obstruction of justice, and election interference.
Identity theft is just a nightmare. It can ruin people's credit for years, their peace of mind. It's a profound violation.
It absolutely is. And perjury, lying under oath. That's a direct attack on the integrity of the entire court system. If we can't trust the testimony, the search for truth, which is the whole point of a trial, completely fails. So it's a felony. It matters a great deal.
Okay, and then we get to level 5. Borderline felonies, high-impact offenses.
Right. So there's a meaningful potential for harm here, but the penalties can vary widely by jurisdiction. We see things like felony DUI, but one where, thankfully, no one died. Forgery is here. Moderate tax evasion.
And here it is, the counterpoint to level 7, rescue lists. Illegal reentry after removal, no violent history.
Do you see the drop?
It dropped 2 whole levels, from a level 7 down to a level 5.
Because the risk is different. The threat profile has changed completely. In level 7, you have a person who crossed the border and has a history of violence. The state has a compelling interest in treating that as a serious felony. But in level 5, you have a person who committed the exact same physical act crossing the border, but without that violent history.
So the severity index demands that we differentiate between them based on the actual threat they pose to the community.
Yes. It illustrates the author's core demand for nuance. You cannot, in a just system, treat every single border crosser as if they're a level 10 terrorist or even a level 7 violent felon if the facts don't support it. You have to look at the individual.
And if you flatten them all and just say illegal is illegal, you lose the ability to prioritize your resources. You can't focus on the person who actually poses a danger.
You waste resources, absolutely. If you're spending level 7 law enforcement resources on what is truly a level 5 problem, you're being incredibly inefficient. But more importantly, you are risking being profoundly unjust. You are applying a level of force and a penalty that is disproportionate to the actual harm.
Okay, let's keep going down the scale. We are now entering the lower tier. This is section 4, and it covers levels 4 down to 2. And spoiler alert, level 2 is where the author really focuses his fire. But first, level 4.
Level 4 is what he calls standard criminal misdemeanors. There's direct but limited harm. The penalty is typically short jail time or probation.
What are the examples?
Simple assault, a first offense DUI, petty theft, vandalism.
Simple assault. That sounds bad, but we're talking about maybe a bar fight, not a premeditated, brutal beatdown.
That's right. A scuffle, a shove. Nobody is permanently maimed, but it's still a violation of another person's physical safety. You can't just go around shoving people, so it requires a criminal response, but a proportionate one. A misdemeanor charge, not an attempted murder charge.
Okay, that's level 4. Then we have level 3, low-level misdemeanors.
This is primarily disruptive conduct. The harm to third parties is very limited. Think disorderly conduct, very low-value shoplifting, trespassing on property where you're not really causing any damage.
This is basically the nuisance category.
It is. It's behavior that we as a society don't want, but it doesn't shatter lives or destabilize the community.
And now, we arrive at level 2. The text describes this as civil and regulatory violations, and Rachewsky explicitly calls this the critical focus of his entire analysis.
This is the heart of the argument. This is where the collapse of proportion is happening most acutely, in his view. The definition of a level 2 offense is administrative harm.
Administrative harm.
The penalties are historically supposed to be fines, civil penalties, or removal from a situation. But, and this is a huge point, no incarceration was historically intended for this level of offense.
No jail time.
Not for the act itself. These are essentially violations of the rules about how society runs administratively. He gives some classic examples. OSHA violations.
So a factory doesn't put a guardrail up where it's supposed to.
Right. Is it dangerous? Absolutely. Could someone get hurt? Yes. Is there criminal intent to murder a worker? No. It's negligence. It's a regulatory failure. Other examples are SEC or FTC enforcement actions, environmental reporting failures.
And this is where the immigration discussion comes back in a really big way. The index explicitly places failure to carry immigration documents, visa overstays, and unlawful presence right here in level 2.
So he places them side by side with OSHA violations and consumer protection paperwork violations.
That is a very specific and I'd say provocative choice.
Right?
Let's do a deep dive on this. Why is a visa overstay a level 2 violation and not a higher level crime?
Well, think about what a visa overstay actually is. A person entered the country legally. They had permission from the government. They were inspected. They were vetted. That permission had an expiration date. Now, that date has passed. The person is now out of compliance with the government timeline.
Okay.
Now ask the key questions. Is that a violent act? No. Is it theft? No. Is it fraud in the way identity theft is? No. It is a failure to maintain one's administrative status. The harm is to the integrity of the bureaucratic system.
Let's compare that to level 6, identity theft.
In identity theft, I am actively and maliciously stealing your persona to defraud you or a bank or someone else. I am causing direct, tangible harm to you, the third party. My gain is your loss. In a visa overstay, who is the direct victim in that same way? You could argue the victim is the integrity of the system, which is the very definition of an administrative harm.
So treating it like a violent crime
Is a category error of the highest order. And this is where Rachewsky's argument gets really sharp. He is not saying that level 2 offenses should be ignored. He's not saying let it go.
Right. He's not arguing for no rules.
Not at all. He lists the appropriate penalties right there in the definition. Fines, civil penalties, or removal. If you violate the administrative code for immigration, the administrative remedy is deportation.
So he's not saying open borders. He's saying the rule is administrative, so the remedy should also be administrative.
Exactly. The consequence should match the nature of the offense. You get fined or you get removed from the country. But what you should not be subjected to is the heavy machinery of the criminal justice system that we built to handle level 8 and level 9 threats.
You shouldn't be hunted down by tactical teams. You shouldn't be held in detention indefinitely without due process, locked in cages.
That's the core of it. The tactics should be proportionate. You're dealing with a records problem, not a violent threat.
It's the difference between a bouncer politely asking you to leave a club because your time is up, and that same bouncer tackling you, beating you unconscious, and throwing you in a dungeon.
That's a perfect analogy. And when the state starts using the dungeon for the person who simply stayed too long at the party, the state has lost its mind. It has lost all proportion. It's an abuse of power.
You know, when we talk about this, I can't help but think about the broader picture of what America's supposed to represent. We have this statue in New York Harbor, the Statue of Liberty, with the poem, The New Colossus.
Give me your tired, your poor, your huddled masses yearning to breathe free.
Exactly, the mother of exiles. It speaks to a certain spirit of the law, a spirit that seems to understand that the desire to be here isn't inherently criminal. It implies a system that should look at the humanity of the person, not just the status of their paperwork.
That's a beautiful and I think very relevant connection to make. The poem by Emma Lazarus doesn't say, send me your paperwork perfect, fully vetted PhDs who have filed Form I-9 correctly.
Well, it doesn't.
It says, send me your tired, your poor, your huddled masses yearning to breathe free, the wretched refuse of your teeming shore. There is an implicit understanding in the American ethos that the desire to be here, to build a life, to escape persecution, that desire is not a criminal intent. It might be administratively messy. It might require regulation, a level 2 process, but it is not malicious, like a level 9 crime.
And when our enforcement treats that yearning to breathe free as if it were a yearning to destroy society, we're betraying that statue. We're betraying the very text we're supposed to live by.
And, as Rachewsky argues, we are betraying the Constitution. His point is that the Constitution applies to persons within the jurisdiction of the United States, not just to citizens. So when you start stripping fundamental rights of due process from the tired and poor because of a level 2 administrative violation, you are eroding the foundation of rights for everyone.
It's interesting, you know, looking at this list, something like an OSHA violation can actually kill people.
Absolutely.
If a factory explodes because of gross negligence, people die. Yet, we generally accept that as a regulatory issue. The company gets a massive fine, there are civil lawsuits. We rarely see CEOs dragged out in handcuffs and prosecuted like we would a drug kingpin.
That's a very perceptive point. There's often a strange inversion. We can be very lenient with corporate administrative harms, even when they lead to death, but we are becoming increasingly draconian with individual administrative harms like immigration status, even when they pose no physical danger at all. Rachewsky's scale is a challenge to that hypocrisy. He puts them in the same bucket. Level 2. Administrative issues that need to be solved with administrative, not criminal, remedies.
Okay, and just to complete the list, let's touch on level 1.
The absolute bottom tier, minimal harm technical infractions.
The examples are speeding, jaywalking, parking violations, expired vehicle registration.
Things like that.
Why even list these? It seems so obvious.
To establish the baseline. To state the obvious because he fears the obvious is being forgotten, a civilized society handles these things with a ticket, a small fine. You pay it, you move on. We do not put handcuffs on you for jaywalking.
Usually.
Usually, and that's the fear, isn't it? As the scale collapses, as the lines blur, the justification for using handcuffs starts creeping further and further down the list.
That leads us perfectly into Section 6 of the text, the constitutional crisis. This is really the so what of the entire deep dive, because Rachewsky argues that when the government abandons this scale, it's not just unfair or inefficient, it's unconstitutional.
This is where he brings it all home. This is the conclusion section of the source material. He makes the argument that, at its core, the Constitution places individual rights above administrative convenience.
Administrative convenience. I feel like so much of modern life is sacrificed to that particular god. Sorry, we can't help you, it's just the policy. It's easier for us to process you this way.
Right, but the Constitution is there specifically to say, I don't care about your policy, I have rights. And Rachewsky lists the big ones, the right to life, liberty, property, privacy, and due process.
And he has this powerful line where he says, these rights do not evaporate at the whim of an agent.
Or get suspended by mere suspicion. This is so critical to his argument. If a government agency suspects you of a level 2 violation, say they think your visa might be expired, does that suspicion give them the right to suspend your Fourth Amendment right to privacy? Does it give them the right to kick down your door in a pre-dawn raid, terrifying your children?
According to Rachewsky, the answer is no.
An emphatic no. He defines abuse of power very specifically in this context. He writes, and I'm quoting here, abuse of power occurs when low-severity conduct, particularly civil violations, is met with tactics designed for violent felonies.
That's the definition of abuse. It's using a sledgehammer to crack a nut.
And it's not just a nut, it's a human being with rights. If the state uses level 9 tactics designed for terrorists and murderers on level 2 individuals, people who overstayed a visa or failed to file the right form, Rachewsky calls that unlawful coercion.
And he's got another great line about that. Detention without individualized due process is not order, it is arbitrariness.
And arbitrariness is the mortal enemy of the rule of law. If the rules apply differently depending on the mood of the officer or the political pressure of the moment or who you are, then you don't have law anymore. You just have the whim of the ruler. That's the road to tyranny.
And this brings us to the future, to the final section of his paper, Section 7, legitimacy. Because this isn't just about the people getting arrested today. It's about the precedent it sets for all of us tomorrow.
He calls it the precedent of danger. And he issues a stark warning. A government that can ignore one right has the capacity to ignore all rights.
It's the classic argument, right? First they came for the socialists, and I did not speak out.
It's a classic for a reason. It's historically true. His point is that if the system tolerates the violation of rights against the unpopular or the powerless, and let's be honest, people in the level 2 categories, particularly undocumented immigrants, are often politically unpopular and legally powerless. If we, as a society, tolerate the violation of their rights to due process,
We establish a precedent.
we tell the government, hey, it's actually okay to ignore the Constitution if you think it's important enough. We give them permission.
And tomorrow, they might decide it's really important to catch you for something.
Correct. Maybe for your tax mistake, or a business filing error, or for protesting something they don't like. But the precedent has been set. The tool of disproportionate enforcement has been sharpened, and it's sitting right there, ready to be used on someone else.
Rachewsky draws this fantastic contrast between legitimacy and efficiency. He says the Constitution does not exist to make the state efficient.
That is one of my favorite points in the entire text.
Yeah.
We so often hear complaints from people in power, oh, due process takes too long, or these hearings are too expensive, or it's too hard to deport people if we have to give every single one of them a lawyer and a hearing.
Let's just speed it up. Let's make it more efficient.
But the Constitution effectively says, slow down. It exists to make the state legitimate, not fast. An efficient state might just round everyone up who looks suspicious, put them in camps, and sort it out later. That would be very, very efficient. But it'd also be a tyranny.
A legitimate state, on the other hand, respects the hierarchy of harm. It respects the process, even when it's annoying, even when it's slow, even when it means a guilty person occasionally goes free.
Because that slowness, that friction in the system is our freedom.
Wow. That is a powerful thought. The friction is the liberty.
It is. It's the space where our rights live.
And the final moral of the piece is just blunt. He says a state that sacrifices rights for the sake of enforcement has, quote, forfeited its moral authority to govern.
It's a heavy condemnation. It means that if you break the law to enforce the law, you aren't the good guy anymore. You've become the very thing you claim to be fighting against.
Wow. Okay, we have covered a tremendous amount of ground here. We've gone from genocides at level 10 all the way down to parking tickets at level 1. We've looked at why the spine of justice depends on keeping these things separate.
And we've looked at the profound constitutional danger of allowing that scale to collapse.
So as we wrap up, let's do a quick recap for the listener. The core takeaway here, the big idea, is that not all illegal things are the same.
Right, that's the whole point. The Composite Severity Index is a tool to remind us that there is a massive moral, ethical, and legal canyon between a violent crime, levels 10 to 8, and a simple administrative violation, level 2.
And the real danger is when we let fear or politics or a desire for efficiency flatten that scale. When we start treating level 2 paperwork errors with level 10 SWAT team tactics.
Because when we do that, we are not making our society safer. We are making our government more dangerous to all of us.
So here is the so what for you, the listener. Because you might be thinking, well, I'm not a terrorist and I'm not an undocumented immigrant, so this doesn't really apply to me.
But it does. It absolutely does. Because this isn't about specific groups. It's about the machinery of the state and the rules it plays by. If the government loses the ability, or worse, the willingness, to distinguish between a clerical error and a violent crime, then no one is safe.
You have a driver's license. You pay taxes. You own a business. You interact with the administrative state every single day of your life. You have a vested interest in making sure that state knows the difference between a mistake and a felony.
Absolutely. If I mess up my tax return, I want a letter from the IRS, not a battering ram through my front door at 5 in the morning.
Exactly. We all do.
And we should demand a system that guarantees that distinction.
I want to leave you with a final provocative thought, something that Rachewsky hints at, but I really want you to mull over. The text says, a constitutional republic does not measure its strength by how aggressively it enforces the law, but by how faithfully it respects rights while doing so.
That's the standard we should be aiming for.
So the next time you see a government crackdown on the news, or maybe even in your own neighborhood, whether it's about immigration or protests or regulations, ask yourself this one question. Does the punishment fit the harm? Or has the scale collapsed? Is what I'm seeing justice, or is it just force?
It's the most important question we can ask as citizens.
Thanks for diving deep with us today. Keep asking those hard questions.
See you next time.
That's a wrap for this episode of The Deep Dive, exploring radical ideas, grounded in reality, driven by reason, built on self-esteem, rational self-interest, and laissez-faire capitalism, produced by Bob Rash.
We'll be back next week. Until then, stay curious, stay free. The joy of music.
The Deep Dive by Bob Rash.
We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness.